ending, you're going to latch yourself to that corporate ID. And that's going to cause you trouble when you actually do realize that you got to go to the court, you got to get that deed release, you got to vest it that way. It's going to cause yourself harm.
Well, you know, this is very interesting because when I showed you guys that Colorado thing where it was a withdrawal of the lands, and then the people said, the registrar said, you know, you have to submit a request for withdrawal, so they did that, and then they were supposed to take that withdrawal and memorandize that on the back of that deed, so that's their release of it, and then you took that release and then they recorded it so that it came back as it was now yours and not theirs anymore. So just like if you did a sale of property, you know, it was yours. I mean, you sold it to someone and then they released it to you, and now it's back recorded to you, and now there's no more lien holder on it or whatever you want to call about it. So that's what they do. But see, what they do is they take your paperwork and then they don't do the memorandum part on the back of the release of the deed. In other words, they're not doing their part, so you're just sit there stuck because, like, I sent it to my registrar. But
the registrar can't do that for you, though. You got to stop. Remember, the capacities is what's handicapping you. So you're acting as a function of government, is all. And in the U.S., they're letting you guys do that now. You're entrapping yourself by pretending to be government. It may feel good at the time, but it's going to cause you trouble. So that's what's happening.
Yeah.
They can't release you.
I kind of understand what you're saying, but when they sign the back of it and they do release it, then that should be going now to the court, not to be re-recorded as an.
Or it's a confirmation. They're confirming that you're now volunteering to be the function of government instead of them. So hey, go about it and do whatever you want. You're supposed to be protecting it from waste, which the citizen's volunteering to do. So now you're doing waste and not protecting the waste from happening.
Yeah, he could always take it in to get it determined too. Exactly what happened here. Because he could have been saying, no, they misunderstood what I wanted. And now he
could
around like, excuse me, no, this is what was supposed to happen here. So what's going on? This was supposed to be released to me in my natural capacity, and this is supposed to be out of your jurisdiction. What's going on? Right? But was it?
Yeah, that's why that's why I kind of understand. Because in a way, in a different way than we're talking about, I guess, but in a way, you are asking for the release of your land because these guys go there and they had, registered it into fee simple, and then they took it out of fee simple. And so they sign it on the back and say, okay, now it's yours, and now it's your title. You can either record that title or not record it. You could hide it under your mattress if you want, but it's your land now. But then you're saying that you need to take that release that you got from them and then go to the queen and get a new title from her. Is that kind of right?
Confirmation.
The
courts do the confirmation, remember? Like, that's because you got to remember the one that's releasing, they only have a use, so it's got to be confirmed by the boss.
Right. So that would be the court. But like I said, is the function of government.
That's 6N. That's where you're going to use 6N for them, right? So that they know where they can have the right to determine if you're living or dead. Get rid of that corporate person. So they've handed you over the corporate person basically to hold. Now you need to get rid of it. They don't let us do that in Canada here.
Yeah. See, how I would handle that is I'd go in and I'd get it determined just the way it is.
And I should correct myself. They do allow it in Quebec because that's what Danny has achieved. And if Tonka's going to go that direction, he could probably hit that way too with their civil code.
Because once you get them into that, I'm sure that you could go into the courts and get a determination on it, and once they determine that you've actually got it in the capacity of fee simple, then you can get then you can fight that determination and get it changed.
Well, technically, they could utilize 6N themselves because it's all in affidavit form anyways.
Exactly.
So then all you would go is get a summary judgment. Like, it'd be really quick for them.
That's kind of what I'm thinking, if they went on it the right way. Right? Like, so, because if they go in and get it determined is like, it's super cheap. It's like probably $250. Then you're going to get a determination by the court seal. That is what you're going to base your next claim on, because they're going to specifically tell you whether or not they transferred that to the defeasible title or an indefeasible title, and in what capacity you have at holding that piece of paper. And as soon as you have them dwindle down to that, now you know the seat in law for that thing that's holding that thing. Now you know how to deal with it.
Yeah, right? It seems like they want to not let you know what the determination is. They definitely try to fight that off. Like, they don't want to make a determination. That's their whole point, because then they keep you in limbo land. At least that's how we feel like it is. We're learning now from you guys how to do it, but that's how most of the people that I know were doing it, and they were, just sitting there going, I don't know if I'm now out of the system or not, because they won't answer. They won't answer back.
That's just it. Is it plateaus you? It stalls you because you didn't know the rest of the process.
Right.
Their test to see what you're doing.
Right.
Well, don't forget, these are all. You got to remember, because freedom, everything is a contingency. So you might approve of this stuff. I may not. So it's an individual choice, and that's why it's called a contingency. And a contingency in law means that if something specific happened, you have to do something specific to get remedy for it. Right? It's specific.
I think that's the problem, is that it hasn't really been clear to most people that when you had a certificate of live birth or whatever, et cetera, like what it really is. So now we know it's a warranty or whatever. And then the next thing is they didn't make it clear that you had to do any determination of that after that at all. In other words, they never said you needed to now take this and go do this if you want this to happen. They never even lead to any kind of point that there's some kind of determination that needs to be made now, or use of that.
Who are you referring to?
Huh?
Who are you referring to? The government?
In the laws, no one's come up in the laws saying that, in other words, like you said, there's a one sentence in Queen Anne that said, that you had to
all the commentaries are telling us exactly what the law is. That's how the judges have been determining things.
That's correct. It's the old ones, right? The really old ones. But any new laws, like what I was talking about with the Colorado statutes or whatever, they say you can go and return your title and then.
I got to stop you right there. Jurisdiction.
Yeah.
Right? Seat law.
Yeah.
Ever since 1535, all law created by the people is equity. It is of no force or effect to those that are not a corporate person.
Right.
And they don't have the authority, right? Because they're all in a use. They don't have a trust. So if everybody that's a citizen and acting as a function of government don't have the authority to own anything, is there a trust? They don't have an inheritance. So how can they even disclose it?
Yeah, I totally agree with you, but I guess there's a level in between that you guys, maybe from Canada, you're not quite seeing, or I'm not explaining it correctly. But in other words, when you take an ownership document, I'm just going to talk it simply. If you take some type of ownership document and you turn it in and you get it transferred over, from whoever had control over it, now it's given back to you, and they sign it on the back, so endorse it back over to you. That used to be like the end of it. There wasn't that, and that turns out just to be the middle ground, because now you're the owner of it, all right, but you're the interest owner of it, not the allodial owner of it. You just got full interest ownership of it. and that now there's another thing. Once you have interest ownership, now you have to go claim true ownership. So interest ownership is a deed, and true ownership would be like, say, a title, and then the title then has to be, turned back over to the queen to get completely out. In other words, there's a few different.
Think plantations, free men, freed men, and slaves, and then you got your master. Right?
Yeah, exactly. Yeah. So when you turn, that's really good, Justin. So when you turn your paper back in, or your manumission from a slave, you now become a free man, but you're not another master until you leave that plantation and go and set up your own piece of land, and then become a master over there of that piece of land. So everyone tries to, they're trying to turn it back into free men, but free men don't. They're just like in the movie Django Unchained. I don't know if you guys saw that movie. It's a great movie. But when the black guy, Jamie Foxx, comes riding into the plantation and he's on a horse, and the black people weren't supposed to be on horses, they said, well, he's a Django, he's a free man. So he was allowed on the plantation as a free man, and he had his own manumission papers. He had been freed, but he still didn't own his own piece of land, so he wasn't a master of another piece of land. Does that make sense?
Yeah, but maybe I have the definitions mixed up in my mind here. But the freedman is the slave that gets out. He still he doesn't have his own lands. So the freemen inside equity in that jurisdiction, there's a freeman inside that, and that's what the freemen on the land are trying to. That's what they are. But there's a free man that is like when you're a donor capacity. So you got your own land.
Yeah. We're talking
the free man.
Yeah, we're saying the same thing. The free man without land, or the man.
But the black guy on the horse coming into the plantation was a freed man, calling himself a free man. He can't be free. He didn't have any land. He was still in equity. He was just a freed man.
Yeah, he was in that middle.
There's a D in there. A D inside that.
I agree. He was in that middle place where he was freed, but he didn't have his own land. So the next thing he would have had to do is he would have then, in this example, he would have had to take his thing to the Queen's bench, right? To get
6 Anne, the same one. 6 Anne.
Yeah.
The same shit's happening today.
So that was the confusion.
Nothing's changed. They're making fun of us with the movies. It's to entertain the actual tenants in fee simple.
Yeah. Is it ever
the slaves?
It's bad.
It's mocking us. They're spitting in our face and calling it rain.
They're making us feel like we're free when we have fee simple absolute, when it, like you said, it has the word fee in front of it. So therefore it's like a middle ground. And that's what I guess I was trying to say. We're got to get out of that middle ground, even though we have done what we're
slaves today have freedoms. So they don't need to get freed. And because they don't need to get freed, they'll never achieve to go to free. So they're never free.
Right, but William had said before that the word free man was still a fee simple term, but now you're kind of saying that a freed man is a fee simple term, and a free man is the one who has his own.
You got to remember that the jurisdiction that you are in determines what the meaning of that word. So because all these people are going up to a corporate court or even to a Queen's Bench court and not having a deed of release and not dealing with that, and they say free man, they're assumed to be within the municipal corporation's jurisdiction. So that's the definition that's going to apply.
Right.
When you're in the capacity of a donor, you are now in the jurisdiction of the ancient land tenure. That is back to when this started. So once you are there and you are recognized as being there, when you say free men, they have to use the definition from your jurisdiction.
Can someone just turn the TV down in the background, or turn it off or something, or mute? There you go.
So are these 3 levels? Could these be the 3 levels? the slave, the freed man, and the free man?
No, because it when we're dealing with the deed of release, you got to be looking at it in the capacity as the fee simple. Can the government stop the fee simple from being a part of the fee simple group? See what I'm getting at? And then once you're in the next level, you got to look at, okay, well, I'm in this jurisdiction, and how does the law apply to people in this jurisdiction, and what rights do I have over things and the people that are holding them in their jurisdiction? See what I'm getting at? So if they're still in fee simple and you're in remainder, now you have the right. Once you're in remainder, actually, I'm not even going to get into that because that's dangerous to start talking about that right now. But
yeah, let me make a comment for the guys that know the scripture. The mighty men, after the angels descended to and mated with the women, there was mighty men that came out. Those are the guys that were in the ancient land 10 years. So when you started abusing that and became a baron and a landlord of a municipality, you become the Nephilim, the devils.
The villain.
Yeah. And the villain's the volunteer to it.
And that's even specific, and that's why it's important to research this from the ancient 10 years from today, each level, because it shows you that all the fee simple that are now fee simple today, when they were called villains. And I talked a lot was a different language and spoken in a different language than the citizens. So,
hey, William, you have to speak a little bit slower. I think the computer doesn't catch up with your voice. It seems to break up when you speak fast.
Another thing I want to make a comment about when I was saying the freemen and the freedmen. William's right that freemen is still your fee simple term. So when you're saying freemen after you've been freed, that's referencing you with your land. Now, when I say free men to you guys, that's just simply the term I'm referencing after we've got our own land. We're all free men. If that clarifies it, or maybe it modified it.
Well, yeah. When William got pulled over, and they said, "Hey, obviously you're in a different jurisdiction, so here, have a nice day." He was being treated as a freed man. That be correct?
I don't know.
No, because he doesn't got his deed release.
And how could they not, like, it was a slave, it was an overlord in the slave terms. An overlord came and found him. He was a slave man who was supposed slave man who was doing the wrong thing. So they pulled him over to correct him. Yet when
they're just security to the overlords. The overlords would be your actual justices that aren't doing the benevolent job of, getting people to come into the court to vest their land. They're just keeping it oppressed. Mm. So when they act as a provincial corporate judge, that's your new baron.
Well, you got to remember that once we get a little bit more deeper into this, and people start realizing what they actually have to look for, you'll see that they can't even stop you from trying to vest your estate and everything with clean hands. So when we actually get a little bit deeper, we will see that nobody has any authority to force you to do anything. And I think everybody can agree on that's basically the way that society is functioning. Except for everybody believes that the government's forcing them to be a part of it. But if we look at the actual contract and what acceptance is and what we're discussing now, on what is required for the release to stop being that corporate person, to stop allowing that jurisdiction to be in place, it should show that all the people that are challenging jurisdiction on YouTube and Facebook and everything have don't have the proper understanding on how the system is set up and all the remedies and everything to this, and how the release of having to release the things before you can release the corporate person, and why the issues that are happening, right? Because if everything that we're going over is all written by top scholars, but what we see happening in the courts by the people that are having all these issues are opposite of what the scholars are saying. Is it actually the law that's wrong, or is it the people that are trying to do what they're doing is wrong?
Well, it's obviously the people, but I guess none of the people realized that, when they followed the law, whatever that was, like, get yourself registered and get a birth certificate, they didn't realize that by doing that, supposedly they're registering for their estate in the first place, but then that they had to now follow certain laws regarding that certificate or that warranty, so that later on, when they turned 18, they could get what that certificate represented. In other words, there was a process to do when you turned 18.
Not 18 though. It can be before 18.
Oh, it can be up to after 7 years, right? So as soon as you have the capacity to understand that, comprehend it, then you can do it. So, but I mean, you got to
remember, it's automatic unless you terminate it by the time you're 7.
It's automatic. What, that you then have to renounce it? You mean? I'm not renounced.
That's right. If you have to. You are automatically entered into it by your parents until you terminate it. And you have to terminate it by the age of 7, right? Or you're automatically incorporated in.
Lost at sea.
Yeah.
The Holy See. You're reliant on the Holy See.
So now you have to, when you become 16 years old and want to drive a car, now you have to do that because you're in their jurisdiction. Right. You only have 7 years to play around in their jurisdiction without any laws. Is basically what they're saying. 7 years from the time of your birth. Right? And it even makes sense because look at it. Is there any English law on the planet that does anything to anybody before the age of 7?
So what I posted up from that Mercer's Beasley's Law Review is correct. That they started a presumption of your death upon your birth certificate. So upon your birth,
not a death. Lost at sea.
Okay. Right. Okay. Well, let me read this for a second, if you don't mind. It's just a couple paragraphs. This is from Mercer Beasley Law Review, January 1936. It's called Presumption of Death in New Jersey, and it says, I'm trying to think where we could start. I guess I should just read it. It says, every person must at some time end this mundane existence in death. After death, a person's estate becomes susceptible to distribution, either by, now I don't know if this is going to go into equity a little bit, but anyway. After death, a person's estate becomes susceptible to distribution, either by virtue of the terms of that person's last will and testament, or by virtue of our statutes relating to descent and distribution. The surviving spouse of one who dies is relieved of bonds of matrimony and is free to marry again. The legal effect of death thus becomes one of important phases of administrative law and of orderly procedure in social affairs. Where death occurs as an actual provable fact, the legal incidents of the death attach at once, and no serious legal questions arise other than perhaps those relating to the interpretation of wills or to the determination of the persons taking the estate of the dead person, according to our laws and statutes pertaining to death and distribution. There are, however, many instances in which death is not a provable fact. One may go on a journey and never return. A man may suddenly disappear from his old haunts and his relatives and friends and may never be seen again or heard from again. A man may be a fugitive from justice or may have serious domestic difficulties or may have brought upon himself some actual or impending disgrace or may have become hopelessly indebted to others. Because of one of these situations or any other, making him desire to avoid contact with others, a man may mysteriously and completely disappear, never again to appear or to be heard from. But at some time in his life, death must come to him. The first presumption is, of course, that a person, once alive, continues to live until the fact of death is proven or until that presumption is overcome by a contrary presumption. At early civil and canon law, it was presumed that a person would be alive until he might have attained the age of 100 years. Under this presumption, one who disappeared might have many years of presumed life before death might be presumed. This resulted in such a ridiculous legal and social predicament that the common law early altered this presumption to the end that a person would be presumed alive until the contrary presumption arises, and then fixed the period for the presumption of life at 7 years after disappearance. At the conclusion of such a 7-year period, the presumption of death arose. This at first was considered a presumption of fact, but our courts now regard it as a presumption of law. If at any time after the 7-year period, the person presumed to be dead reappears or is heard from or is proved to be alive, the presumption of death is of course rebutted. The common law presumption of death has now become fixed in statute by most, if not all, of the states of the United States. Our first New Jersey statute, this is from New Jersey, relating to the subject was enacted in 1797. It was a declarative of the common law at the time and is commonly known as the Death Act. It provides as follows. Section 1. Any person who shall remain beyond sea, SEA, or absent himself or herself from this state, or conceal himself or herself in this state for 7 years successively, shall be presumed dead in any case. And it has a lot of the law sites and all that kind of stuff. But I was thinking that maybe when they did the birth certificate, that's when they brought up the first presumption that this person may be dead. And then if you don't claim it by the 7 years, then that presumption can be validated or whatever. And then they send in an administrator to start administrating the state. And that maybe the thing happened.
I would say no, it's all equity. The gone to journey and stuff, that's just changing your domicile within the Liber de Wittonia, so the Doomsday Books. So any of the municipal law jurisdiction corporations. That's what just mystery of disappearing is, right? So I could disappear to another domicile, but not be dead.
Yeah.
And that's all that's talking about, I think. Because the CSEA is literally referencing the oceans and your naval commerce. The SEE is your equity.
Mm-hmm.
So the death certificate isn't going to do anything, I don't think.
Well, this guy I heard, and this is his chatter now, but this guy, he had done this very same thing, right? He was a drunk and I guess was chasing women and left his wife and everything and took off and wasn't heard from for like over 9 years. And so she had him declared dead at 7 years because he had a life insurance, I guess, and he had kids, so he could take care of the kids. So she went to court and had him declared dead. And then 2 years later, he came back, and this is the actual story. It was on the news and everything. And he came back and he tried to reclaim, his name and said that he was alive and everything. And the judge wouldn't give it back to him because he said, "You've been declared dead and you're now stateless. You have no name." And that's how he was. And he didn't have a name anymore because it would have been declared dead. He didn't have a person, I should say. But he didn't have a
right.
name.
So maybe I should say the death certificate then would void out your warranty for land. So now you wouldn't be able to come in and say, "Well, this is my land." They'd be like, well, you're dead. You'd have to start anew.
He'd have to have proof of indenture.
Yeah. Yeah, you'd actually have to have the copy of your indenture. If you got that, then it'd work. But say you didn't, and you just bailed on your family, you just left and went to move to like Japan or something, and that's what happened is they declared you dead and you came back. You had no copies of anything, no proof, nothing. Yeah, then you're in trouble.
I don't know if he had proof or not. I guess he didn't. I don't know.
You also got to keep in mind that all the two jurisdictions are mirrored, right? Except for the common law is based on the donor and the land tenure, and the equity is about the use and trust. So, where the land tenure is about succession, right? Use and trust is about heirs. So they made the same laws pertaining to that corporate person. Because I guarantee you that if that guy got picked up, he still has a corporate person because it's going to be to the government's benefit.
Yeah.
If you see what I'm getting at. Right? Because he doesn't have his release and all that other stuff. So when it comes to the government's benefit to come and push civil acts and legislation onto you.
Yeah, it was a BC.